There are a number of open meeting laws that affect local and state governments in California. California has three types of open meeting laws that apply to local and state governmental entities. These laws have been adopted over the years and apply to state agencies and departments, the legislature, as well as local entities such as city councils and boards of supervisors. These open meeting acts are generally referred to as Bagley-Keene. The Bagley-Keene Open Meeting Act applies to state entities. LOMA, the Legislative Open Meetings Act, applies to the legislature. And the Ralph M. Brown Act, or the Brown Act, applies to local entities. So let's take a look at these three acts broadly. So the first is the Bagley-Keene Open Meeting Act. And Bagley-Keene, as it's known around the capital community, was adopted in 1967, and it implements relevant portions of the California Constitution, which declares that the meetings of public bodies and the writings of public officials and agencies shall be open to public scrutiny. Now, the state constitution mandates open meetings for state agencies, boards, commissions, bureaus, and other entities. And it's similar to the Brown Act, which applies to meetings at the local government level. The Bagley-Keene Act provides that the people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments that they have created. The Bagley-Keene Act provides in Government Code Section 11120 that it's the public policy of this state that public agencies exist to aid in the conduct of the people's business, and the proceedings of public agencies be conducted openly so that the public may remain informed. In enacting this article, the legislature finds and declares that it's the intent of the law that actions of state agencies be taken openly and that their deliberations be conducted openly. Now, the practical impact of the Bagley-Keene Act is that state agencies and departments must provide members of the public with the opportunity to address agenda items in public meetings of the respective state agencies or departments, boards, commissions, etc. Before the ability to comment on an agenda item, the public must be made aware of any meetings of the state entity. As a result, notice of state agency or department meetings are required to be provided to any person who makes a request in writing at least 10 days in advance of the meeting. Notices must include a specific agenda for that meeting, including the items of business to be transacted or discussed by that state agency or department, and no item may be added to the agenda subsequent to that public notice. Now, state entities may take action on items of business not on the agenda in certain very limited circumstances, most notably upon a determination by a majority vote of that entity that an emergency situation exists. In addition, the Bagley-Keene Open Meetings Act requires a state agency to conduct any meetings or function in any facility, it prohibits them, where there is a prohibition based upon race, religious creed, color, national origin, ancestry, or sex. There are some important aspects of the Bagley-Keene Act to understand, including what is defined as a meeting, what is a state body, so to what it applies, and what's an action taken. There are also authorized closed sessions in Government Code Section 11126, which says that closed sessions can only be held by state agencies under very limited circumstances for appointment, employment, evaluation, or discipline, including dismissal of a public employee, for licensing, honorary degrees, real property negotiations, and investments, and to confer with or receive advice from legal counsel regarding pending litigation. And the law has strict requirements regarding a notice of a closed session, what must be disclosed to the public, and what must subsequently be reported in the open session thereafter. Turning to the legislative open meetings law, the legislature is bound by the legislative open meetings law, which is found in sections 9027 to 9031 of the California Government Code. And you ought to be aware of the following major provisions of that act, LOMA. The caucuses of the legislature have the full authority to meet in closed sessions. These are the two political parties in the two houses, whereas state agencies have limited authority to meet in closed session. Obviously, the party caucuses in the legislature have full authority. Also, legislators can meet informally outside of committee meetings and floor sessions to discuss policy so long as no formal action is taken privately, and so long as less than a majority of the body is involved. Staff and other intermediaries working on behalf of members are not counted, and serial meetings are not prohibited, although the Bagley-Keene Act prohibits serial meetings and does count staff as board members of the state agencies. Legislative leaders can also meet with one another, as well as the governor in private, to develop policy proposals so long as the product is brought to an open committee meeting or a floor session for adoption. Note here that designees of a state agency engaging in the same activity would constitute a committee or an advisory body, which must therefore meet in open session. There are a number of provisions related to the Open Meetings Act that you should be familiar with, including that generally all meetings, once a quorum's in place of a house of the legislature or a committee, must be open and public, and all persons be permitted to attend the meetings. Also, any meeting that's required to be open and public can only be held after full and timely notice pursuant to the joint rules of the Assembly and Senate. And in Government Code Section 9029, either house of the legislature or a committee of either house of the legislature is authorized to hold a closed session for one of three specified reasons. And as I mentioned earlier, a caucus of the members of the Senate, the Assembly, or of both houses, composed of members of the same political party, may meet in closed session at any time. Also, each member of the legislature who attends a meeting on the floor or any committee that violates the Open Meeting Act with knowledge that the meeting is in violation of the law is actually guilty of a misdemeanor. And finally, there's the Ralph M. Brown Act, known of course as the Brown Act. It was adopted back in 1953, and it applies to open meetings at the county and city levels of our local government and is found in the Government Code, starting with section 54950. The purpose of the Brown Act is to guarantee the public's right to attend and participate in meetings of local legislative bodies. According to the proponents of the Brown Act, city councils, the County Board of Supervisors, and local government bodies were avoiding public scrutiny by holding closed workshops or what they called study sessions. And so the Brown Act applies solely to California city and county government entities, including their boards and commissions and councils. It's really comparable to the Bagley-Keene Act that again requires open meetings of state government agencies. So the Brown Act contains a number of findings and declarations that public commissions, boards, and councils and the other public agencies in the state exist to aid in the conduct of the people's business. And so it's the intent of the law that their actions be taken openly and that their deliberations be conducted openly as well. All local entities in California are bound by the Brown Act. Some of their major provisions include that a majority of any decision-making body, 4 members of a 7-member city council, 3 members of a 5-member board of supervisors, may not decide amongst themselves on issues within their jurisdiction, except in open and publicized meetings that are held within the geographic boundaries of that local government entity. These local agencies must publicize when and where their meetings will occur, as well as what will be discussed, so that the public can observe those meetings. It's required at least 72 hours or 3 days notice. Now note that this is different from the 10-day notice under Bagley-Keene at the state agency level. Next, no action can be taken by the local government decision-making body until an item has been placed on the agenda for their consideration. There are no secret ballots allowed, whether final or preliminary ones, and the public has a right to be heard on matters on the agenda before the decisions are actually made. The public also has a general right to address agency decision makers on items of concern to them, even if they're not on the agenda. This is typically called a public comment period on the local government agenda. Similar rules and restrictions are when closed sessions may be held. There's a prohibition on serial meetings, one after the other with the different members. And it covers committees and advisory bodies of local governments as well. As I mentioned, I think the Brown Act is nearly identical to Bagley-Keene for penalties and other provisions. And if they want to challenge a violation of the Brown Act or the Bagley-Keene Act, you must do so within 90 days and give that agency an opportunity to remedy the violation before you can file a lawsuit. So again, this is just a summary of some of the key provisions of the 3 open meetings laws in California. The fundamental purpose is to provide public notice and an opportunity to participate in the meetings of our local and state bodies, as well as the state legislature, before any final actions are voted or votes taken by these bodies.